well? That's a good question. I think so, yes,
We're ready? Okay.
it would.
Good afternoon. Welcome to the June meeting of the Rehoboth Beach Board of Adjustment. We'll start with a roll call.
William Pearlstein.
Edie Heron.
Barry Brandt.
Fred Townsend, Town Attorney.
Okay.
Board Attorney, excuse me.
Mark Saunders and Jan Konesi are excused this afternoon. And for today's meeting, was the meeting public notice properly posted?
The agenda was posted in City Hall and on the city portal on June 15th. It was also sent out from the portal the same day. The agenda was amended and reposted on June 20th and June 23rd. Public notice for case number 0223-02 for the property located at 40 Park Avenue was posted in City Hall and on the city portal on June 6th. The public notice was published in the Cape Gazette on June 9th and June 13th, and Delaware State News on June 8th and June 9th. Notification specific to this case was mailed out to the property owner addresses within 200 feet of the subject property, and signage was posted on the property. That's all I have.
Thank you. And I do see we did have correspondence for this case. Was any additional correspondence sent after this last? Okay, we're good with that. Okay. Do we have any minutes to approve? Okay, no minutes. And I do know we have two notices of decision. So let's go and take care of those first.
Okay. So do you want to start with respect to 1 Rehoboth Avenue?
Yeah, let's do 1 Rehoboth Avenue
Case
first.
number 082210.
And I assume that's the most recent one that we've seen?
It is.
Okay, Fred,
Correct.
thank you.
As for any discussion on that, or, I mean, I've reviewed it, went through.
I have too, several times.
Bill?
I've reviewed it, I'm fine
Okay.
with it.
Right, I'm good with it as well.
So can I have a motion to approve?
So
I'm-
moved.
Of second.
Okay. All in favor?
Aye.
Okay.
Thank
Approved.
you.
All right.
Need to sign that, Fred? Or is it a?
I'll circulate that right
Oh,
now.
okay.
Okay, and then the second notice of decision was for 229 Hickman Street, case number 1022-09. Did everyone get a chance to review this notice of decision today?
I did, and I'm fine with it.
I did, I just have a question. Fred, we refer to 18 to 25 people plus 4 sets of in-laws. I'm not sure whether she said there were that many people. If folks are certain that's what it is.
I recall saying 40 individuals.
40, well, that
40.
would be 18 to 25 plus 4 sets of in-laws.
So I did review the videotape
Yeah.
of it, and that's where I got that information
Okay,
from.
that's fine. Just wanted to check.
Looks like a typo, though, I have to agree.
Yeah.
All right.
I do-
Otherwise, that was the only thing I noted.
I do have a question in the third paragraph under summary of evidence. In the second sentence, it says, in agreeing to purchase the property, she relied in part on representations that the 1,123 square foot basement. Does representations have to be expanded out or clarified, or is it okay, as it reads? Would there be any ambiguity?
You mean representations is like who made them?
Correct, which she said the builder made representations that she could, expand the do whatever, If it's okay as is, I'm fine.
She relied in part on representations that the 1,123 square foot basement could be finished so as to provide additional habitable space.
And then it does go into, you do clarify it saying the builder, which, so I believe it's okay. I just wanted to check on that.
That is what that is meant to
Okay.
be a reference to, is the builder's representation.
Okay. All right. May I get a motion?
I move that we accept the decision as printed here by Fred.
Second.
All in favor? Aye.
Aye.
Okay, that's good. Let me sign real fast here.
Thank you.
Okay. Okay. Okay,
You're not on that page.
let's turn it over. Should be there somewhere. Okay. All right. Back to you. Okay, as for old business, I would imagine the old business first would be, do we need to vote on the requested today for a rehearing?
That's the new business. I
I have
have
the case under new business, but
Right.
I said, is the
I
vote?
I actually have an old business, and this is perhaps for Ann. I received, and maybe, I think we all did, an email from Christine Now a couple weeks ago asking about if I would turn in my code book, or if I could tell her what number of my code was my code book. And I emailed her back, and I said, what's a code book? I don't know. Okay, I didn't know because it was addressed to all the members of our board with a copy to Fred and to you, and I thought perhaps it was,
Yeah.
okay, great. Well, then, I have nothing else for old business. Thank you,
okay.
Barry.
All right, then under new business, I think that, Fred, the first thing we need to do is vote on whether we can have the rehearing.
I have
correct?
questions.
It's for me or for the applicant?
For, about the process of a rehearing.
About the process?
Well, when does a rehearing happen? Is it when an applicant has made an error? Is that?
Fred has.
Well, the rule in question is Rule 16C, which enables an applicant to request a
Okay.
rehearing under certain circumstances, and those are the three listed: mistake, inadvertent, surprise,
Okay.
excusable. Yep.
Okay, I do have another couple questions about it. And why would we consider or not consider a rehearing? Are there reasons for us as a board to hear or not hear? Since that's listed as a part of a reason, then it's appropriate for us to hear it. Is that correct?
I would look at it more in terms of it being a duty or an obligation of the board if you come to the conclusion that the criteria or one of the three criteria have been met.
I see. And are there any implications for us as a board if we rehear it, or if we don't rehear it? Are we making ourselves vulnerable for further action from someone if we decide not to rehear it?
Well, if an applicant makes a timely request and this group were to conclude that one of the criteria are appropriate to justify the rehearing, then you would have an obligation to rehear it.
Okay,
If you concluded that the criteria had not been met, it would be an act of the board that could be perhaps subject to
Questioned.
appeal.
okay. If we end up granting the rehearing, what happens to the old variance? Is it nullified, or is it, would we be amending it in some form? So notice what happens to the old one?
Well, it would depend on what you decided to do. I mean, I can think of a circumstance not that long ago in which this board granted a rehearing and then denied the application essentially a second time.
Right.
So the board agreed that there were grounds for a rehearing, but ultimately did not grant the application. So any number of possibilities are available. You can deny the request, you can approve the request, you can approve the request and deny the relief requested in the application as well.
But my specific question, that's part of it, Fred, but my specific question is, if we end up granting this application for the rehearing, what happens to the variance that we have already granted?
Well,
Or
it
is
would-
that part of the motion
It reopens the matter.
entirely?
Yes. Well, specifically as to the application. I mean, when I say entirely, it doesn't mean you can consider things that weren't part of the original application.
Let me ask a clarification. Since the original case had two aspects.
Right.
I would think we are only discussing the one in the first stance. So I would say to Fred, it's an amendment.
So the applicant has submitted some materials.
Right.
Which clearly relate to only one aspect.
Correct.
Of the variance that was
Right.
granted.
Right.
And I think it's fair, and I'm getting a head nod from Mr. Robertson, that that will be there won't be anything beyond that issue raised in the rehearing.
But if we would grant this new variance from the rehearing, if we would grant it, will there then be two variances on the books granted by this board? One that we granted a couple months ago about both issues, and then this one that would overwrite the beginning of the one issue.
I see
Maybe
what
I'm
he-
going crazy here,
no, I see
but
what he's getting at.
I'm a detail
Does,
person.
hearing this case today for the first variance from the last meeting,
Right.
so the second one stays as is. This one would overlay or supersede whatever the proper wording is for that. In other words, the first one from previous month is no longer valid. This decision here is what,
But they're not all encompassing. The first one were decisions that this board made on two variant
Correct.
situations.
Well, I think we only made a decision on one variance. I think the action or the effort, if I remember correctly, to legalize the.
Carriage house or whatever
Yeah,
it was
but that was
called.
not really what the record supported, but the garage with the shower installed did not result in any official action because I don't think a motion passed. I think we had a couple efforts maybe, or at least one effort to approve a motion, and it did not pass for lack of getting a third vote.
I think that on E's question, they have not moved for reconsideration or rehearing as to the garage, whatever
Right,
that is. So
right.
that, in my view, that is not in front of us. That has
Right,
not been
no,
properly
right, I
noted.
agree. I agree 100%.
That's not been properly noticed, so no.
Agreed.
The first, if we grant the motion for rehearing, it means we reopen our reconsideration. We will then have to decide what our vote is. I agree with you that you don't want to leave two variances, so I would think that we would work with Fred that if we were to grant it, not prejudging anything.
Right, I'm not
that
either.
you would be modifying the earlier decision to reflect X, so there's only one variance that's out there.
So the whole variance would be rewritten with both issues?
No, there would be a new decision
Okay, okay,
today
okay.
saying that the motion has been made to modify the decision dated X, and we either vote yes or no to modify it. But you're not reopening everything
Right.
else. For no other reason, you don't want to reopen the time frame for somebody to take an appeal or something else on the other aspect, which is not being, they've not sought to,
Right.
to change our decision on that.
Okay, Bill. Yeah, I just didn't know where we stood
yeah, no,
with
it's-
it.
I
So
where
I
you're-
thought
I
I
see where
thought I
you're coming
wanted to
from,
ask,
Yeah.
before we even started this, kind of where,
A lot of judges on appellate courts ask exactly that question.
okay.
So we will need to hear from the applicant in a second, but one other thing. The effort to reopen the hearing is not, well, in response to a question you asked just now, are we having a whole new variance hearing? As you can see, there are fewer people in the room
Sure.
than were then. Well, I think we're going to agree that we can incorporate the record that was created during the first hearing and rely on factual representations that were made then. So we're really just questioning whether the variance that was granted with respect to its dimensions should be either extended or not.
I think
to rehear that.
my own view, Fred, would be anything added to the record should be limited to the question that Vince put in front of us. So I think it'd be improper
I would agree with that.
to have other evidence in on other aspects. They said that there was a mistake in the plat, which is what led to the alleged error, which is the grounds for rehearing. And I think that the evidence should be, my own view is that the evidence should be limited to that issue because that's all that we are reopening. We are not reopening the consideration of every other aspect of this, because we've had a hearing, we closed the record, people, as you said, were noticed, were here, heard about it, and I would think that that's what, the only thing that we should be considering
That's a
today.
better characterization.
You want to turn that into a motion?
I don't know if you need a motion, but I think,
So the notice of decision would be amended, is that what would happen probably for that case?
If you chose to.
If, I know, but I'm
Yes.
doing parenthetical.
yes, Your Honor.
We're okay to
Bill.
proceed, so, sorry about that. So,
That's
No,
fine.
but
And,
we haven't voted yet on the motion.
that's what I just asked. Do we need a motion? You-
I
you
think,
said
no, I think we need a motion to grant the rehearing.
Yeah.
Well, I think we do too, but I think we should hear from the applicant to explain.
Right.
Why they should,
Okay.
Because
Fair
the
enough.
applicant needs to meet this test.
absolutely, good, right.
no, Vince Robertson with Parkowski, Girk and Swayze, and as I was before, I'm here on behalf of Mr. and Mrs. Wagner, who, actually, Mr. Wagner, Mark Wagner, who's here, he owns the property with his sister, and the property most affected, the one that's the subject of the error we're hoping to correct, is where Mr. Wagner hopes to build his house, plans to. No, a good conversation, and it sort of leads me into my remarks. It is, the rules permit a rehearing in situations like this. Just for the record, the hearing occurred on March 27th, 2023. The decision was provided to me and my clients on May 9th, 2023. We submitted our request for the limited rehearing, which is what my letter said, that kind of answers some of the discussion, on May 18th, which was within that 10-day window for doing so. So as I indicated in that letter, there was an error that we found out about after the hearing in that signed and sealed survey that was relied upon during the hearing. Frankly, it was an oh no moment when we got the written decision, looking at the written decision, looking at that survey, and physically looking at the house. And we all relied upon it. I remember during the hearing, I think it was towards the end, one of the members of the board actually asked, our letter stated 20 feet, and that was the application. One member of the board, I don't recall who, said, what were the dimensions? And candidly, I looked at the survey, which is on the screen, and it said 14 feet. And that's what I recited. Turns out it's actually a little more than 19 and a half feet. That's why we requested that to be changed to 20. The standards for the rehearing, they are fairly limited. One question that was asked is whether this creates a precedent. I've been involved in these, as has Mr. Mendelis and Mr. Townsend. It's my view that it does not, because each one of these stands so much on its own circumstances. What I may argue is a mistake or newly discovered evidence is unique to this situation, and any other one you hear would also be unique. So the fact that you act one way or another today doesn't impact future decisions. And as far as, we're not, just for the record, we're not trying to reopen the record or the hearing on either variance. We know the one for the carriage house or garage or whatever got denied. It was denied. And we're not seeking to reopen the entire record, although I'm going to admit it to the record just for the sake of procedure, but we're not seeking to re-argue. I'm not going to go through the whole hearing again. I'm sure you're thankful to hear on the basis for that side yard setback variance. It's limited to just correcting the measurement. And the standards for that, there's kind of two that we fall under. One is newly discovered evidence, and there's cases all over the place that talked about that. Is it newly discovered? And obviously, yes, it is, because it was discovered by us that there was an error in the survey immediately after receiving the written decision. And that is an error because we've got the new survey that shows that it is larger than 14 feet. And was it material and relevant? Yes. I put a sort of a caveat to the yes, because your decision, all of the findings of the decision stand. The findings don't change based on this change in measurement. When you look at findings 1 through 13 of your decision, they're all still in play, and they don't talk about it being 14 or 19 and a half feet. But it's relevant in that the house isn't 14 feet long. I mean, that's a showstopper, frankly. And, was it relied upon by everybody? And of course it was. Again, a signed and sealed survey, we were all entitled to rely on that. So that's the newly discovered evidence standard. The other one that I think is equally important based on your conversation is mistake, and there's the myriad of cases and decisions on this. And one of them that I found that was fairly on point, and it said, paraphrasing, but where the error was purely computational and the revision is consistent with the overall adjudication, a correction's appropriate. And sort of further in that, the court, and it was a Court of Chancery decision, said that it has an inherent ability to correct judgments containing clerical errors. This isn't quite a clerical error, it's a surveyor's error, but it's the same idea. I don't think it goes to the heart of the variance that was granted. So, really in terms of the request for the limited rehearing, it's one error and it's one of measurement on a survey by a professional surveyor in the state of Delaware. And as I mentioned, all the board's findings of fact, which are numbers 1 through 13, are unaffected by this correction. So the fundamental basis for the variance remains the same. It's just making sure that correction is accurate. There's one other aspect of this too that we didn't touch upon, but as I was preparing for this, when you look at the surveys, frankly, both of them that Foresight did, they talk in, 9.3 feet, instead of 9 feet, however many inches. And I know that the decision talks about inches. We've got a survey that talks about feet. It'd sort of be nice to get that consistent as well. Frankly, it's a lesson learned for me. Every time I order a survey that's for something like this, I would ask them to do it in feet and inches because I think that translates better to a setback argument like this. So anyhow, that's the basis for this limited rehearing, and it's essentially to change 14 feet to less than 20, like I argued in that letter. So.
Thank you. So that we go to a motion to allow the rehearing.
You're asking whether.
Yeah, we need a vote.
I would move to grant the motion for a rehearing.
I'll second that.
All in favor?
Aye.
Okay.
So with that, do I proceed to the rehearing? Okay. Yes. So what I did, this is all information that's in the record, either from the prior hearing or that's been submitted to you. And I believe Ms. Womack made copies of it.
Yes.
And I thought it would be helpful just to kind of go through this, although we touched upon a lot of it already. So what you have on the screen is the incorrect survey that we all relied upon in the prior hearing. You can see this is the dimension we're talking about. It's 14 feet when the house is rotated. And this is the same spot over here on that. So as I mentioned, it's not 14 feet. It actually is a longer wall that's 19 and a half feet. The next survey is actually what was in the record. It was the PowerPoint that we used, and then I circled the areas. It's just the same thing as I just showed you. Again, this just shows the area in question. This run is 19 feet. There's not an indentation right here like what is shown. That's a wall that goes all the way across that side facade. So when we got the written decision, first thing, frankly, that I did was went out to verify that the survey was wrong. And this was, these letters were attached, or these photographs were attached to the original submission that was sent. This shows that facade. And to give you some indication of what we're talking about, this porch currently exists. This faces the rear of the house. And we talked about this. The reason there's big X's through it is that porch is coming off, so that's really irrelevant to the conversation today. But you can see this facade is all one solid facade. There is an entryway here, but it's all part of that rear facade or the south facade of the structure. This kind of shows it a little bit better through the trees. You can see that, if you can follow my cursor, this is all one facade. It's all one foundation that runs 19 feet. There is an entryway under the second floor of that facade, but that's a solid foundation that runs all the way across. You can see it on the right-hand picture as well. And you can see my tape measure down there at the bottom. Since we didn't have the benefit of a survey at the time, we had ordered it immediately from Foresight when we realized that they had made an error. I wanted to make sure we had the basis for the rehearing in the record within a timely fashion, so that's why it was measured. And again, you can see that's the foundation that runs all the way under the house that connects up top. This is the tape measure that shows the eastern side of that foundation, which shows the 19 feet here. That's the foundation measurement. As you can see, the the porch floor and some of the structure extends out further than 19 feet, which is why we asked for it to be less than 20 in the rehearing. The next set of photographs are just the same thing. This one on the left just merely shows that I started the left-hand side, or the western side of that measurement on the western corner of that foundation. And this you can just see is that tape measure again. It runs all the way under that porch that's coming off. And this is just one more place where you can see that that is a complete foundation. It doesn't, as shown on the original survey, it would suggest that somewhere in here, the home actually jutted in a couple inches that would have made it compliant with the setbacks when it's rotated, when in fact, that's all one solid facade the whole way across. So this is the corrected survey. And you can see, here's that same corner up here, and it shows 19 feet, actually 19.5. This is just a blow up of this section over here, and it shows the 19.5, and it's 9.3 feet in both corners. And so if you recall back on those pictures, there's sort of that interior porch entryway. That's what this is right here. This is actually stairways or a stairwell that doesn't exist right now. When the house is rotated, that's going to be a newly constructed stairway that complies with the setbacks that allows you to go up those stairs and into that door. Obviously, we didn't turn it that way because that would have been an encroachment. But again, this is the corrected survey that Foresight did in response to our notice to them that they had an error. The only thing, this is just the portions of your decision, and I put these on here just to show the only places we're talking about changing. So this is the first page of the decision, and it talks about the measurement, and it references a distance of 14 feet. That's actually the same thing I just highlighted over here. Down here at the bottom, it talks about a 14-foot portion of the dwelling. Again, that's just the same thing I highlighted over here. And then the only other place it shows up is in finding 14, where it said, in other words, the grant of relief was to accommodate 14 running feet of the present structure, including extending 8.4 inches into the restricted area. And as I mentioned to you, the change that we wanted to make is to have those phrases now reflect that it should be no more than 20 running feet of the present structure extending 8.4 feet into the restricted area. So really, that's the extent of it. A couple things that I would like to point out before I'm going to call Mr. Wagner up just to confirm everything I've stated. I did note that there was some opposition letters in the record. It struck me that as the conversation was earlier, none of those are pertinent to whether it's 14 feet versus 19.5 feet in terms of the variance. The board has already essentially approved in findings 1 through 13 the relocation of the house and a setback variance. It's just whether the setback variance is 14 feet or 19.5 feet or less than 20 like we've asked for. So, you know, and we had a lot of people here. We had a full hearing on that. We're not asking to reopen the hearing to discuss all that. The other thing is, I know that and I think the lady who wrote the letters here, hello, this afternoon, and she's concerned about Mr. Wagner's current house and how that impacts her property. As I said at the hearing before, there's a positive outcome of this with regard to both parties, and that is if this house is relocated, it's going to be rotated away from the neighbor's house. So there'll now be a separate 50 by 100 lot between the two of them with a brand new house that somebody's going to build, whether it's Mr. Wagner's sister or somebody else. So, you know, this home is no longer going to be next to her property at all if it's relocated. And then the third element is, you know, there was concerns about the sort of the condition of the home. I would just point out, first of all, that it's a 100-year-old home, but second of all, you know, their plans are, and they've talked to Mr. Janis's team, their builders, to relocate it, do a lot of renovations to it, new windows and other things that obviously cost a lot of money. So they're not going to replace the windows now, only to relocate the house and have to do all that after it's relocated. When they're going to have to redo wiring and plumbing and everything else, that's going to be all one project. So I don't know that any of that's really relevant to the consideration this afternoon, but I just did want to get those points into the record. So with that, Mr. Wagner, if you could come up and you're going to have to give your name and get sworn in this afternoon. Oh, it might not be on.
Here we go.
Thanks, Matt.
All right, Fred. Fred will swear you in.
Yes. Name and address for the record.
This is Mark Wagner of 40 Park Avenue locally and 1734 Independence Avenue Southeast in Washington, D.C.
And Mr. Wagner, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do so swear.
Thank you.
And if I might, can I just say
Well, just real
one
quick,
thing or no?
you've heard everything that I've stated to the board this afternoon. Do you agree with everything that I have explained to them?
Yes, I have, and I did want to just provide a very brief clarification, which is that when we applied for this originally, as Vince Robertson Esquire said, we did want to apply. We did apply for 20 feet, and there was that confusion in the board questions about the lower level. Clearly, the facade is 19.42 inches, 19.42 feet, and for a run of somewhere around 8 and so inches is somewhere between 4 and 5 square feet. So in addition to what was already approved, the incremental amount is like 4 to 5 square feet. That's all I wanted to say. Thank you for your time.
Okay. Thank you. All right. I think I need to ask the city, any comment?
Are you done? Yep.
Oh, I'm sorry,
Well,
Vince.
I'll
Yeah.
just conclude with this. I would like to apologize to everybody involved. Obviously, this is regrettable. If we had known that there was a surveyor error, we would have had that corrected before the hearing. And I do appreciate your time and allowing us to come back forward to get this corrected, because 14 versus 19 and a half feet, you approve the variance for the setback encroachment, but the way it's written into that decision, that effectively makes it impossible to comply with.
May I ask Vince a question? Why does the newer survey still have October 21st, 2019 on it if it's been revised?
That's a good question.
Yeah, it is, isn't it?
Yeah, we went back to Foresight.
That's the same date as on the original one.
Yeah,
that was
I will tell you, because
it said
it's-
existing circuit, because the existing, I noticed that when I was looking back over, I said, boy, that's the same date as the ones we looked at in March.
Yeah, no, and I have no idea, because when we went, so what happened, we had the hearing, we got the written decision. Written decision said 14 feet. Mark calls me up and says, not 14 feet.
Yeah.
I go out and take the pictures.
Sure.
Because I wanted to make sure we were within that 10-day time frame. We immediately, Mr. Wagner and the contractor, got in touch with Foresight to get it revised, and that took several weeks. We got that, as soon as we got the May, whatever the date that we got it into Ann.
Said May
31st.
9th.
Well, no, we followed up when we got the survey with an email
Oh.
to Ann around May 31st, after they went out and reshot it. I can't tell you why it says October 21st, 2019, but I can
Because
tell
that's
you.
definitely incorrect, and that gives the wrong impression.
No, that's a fair point. The problem was, we were running out of time to get you any information.
I understand. I'm just pointing it out.
Yeah.
So for the record, this copy will be in the records with the city. Does the city have any issues with it being, I guess,
Poorly dated.
Poorly dated, as long as it's correct in the survey?
The tactful words are poorly dated.
As long as the submission material is up to date, like, we don't have any problem with the poorly dated survey.
Good catch.
Okay, okay. And then, may I ask city yet, or no, where are we in the?
You can if you wish.
Matt, I had a question for you. As I was looking back over this, I assume that what is still true is that the setbacks are all okay here. The front, the rear, the sides, that I know that we're not reconsidering per se, but I just wanted to be sure that we hadn't missed something else. I guess that's
With the
where I am.
exception of the ask, yes, all the other setbacks are
Okay.
in conformity.
Okay, thank you for verifying that for me. That's all I had for the city.
Questions? Bill, do you have any questions? Okay. I do not have the questions. I do have one question. I take that back. We saw in the decision, and this is for Matt. that the house remaining substantially as it currently exists in terms of the footprint. How in the future does, substantially as it currently exists get enforced? I'm thinking of a house I just saw on Hickman Street. It was a very, very old house, probably well before this house. And it's been completely redone, very modern looking. The idea here is to keep this lodge. How do we get into remain substantially? I mean, we have promises. I mean, I did hear that is on record. Is that good enough for the city that it remains?
So I think what that is a reference to is to the footprint, that the footprint is not going to substantially change.
Okay.
It's not an architectural condition.
Comment. Okay.
Yeah, it's more that there's the tiniest bit of wiggle room is allowed in a major project like this, but that the footprint itself is not gonna change substantially.
And I recall that conversation, and it might have been from Ms. Conacy, is if we grant this,
Right.
is it down that whole side yard? And we said, no, obviously no, 'cause that's a different structure. So I agree with what Mr. Townsend just described, is it, and not the footprint of it as it currently exists, sitting 90 degrees differently, because there's, like we said, there's porch coming off, but as is shown on the survey that we submitted being 19.5 feet.
But listening to, and on the record, I did listen to the entire march. I was not at that meeting. I listened to it and am up to date. I think you made a comment. It's going to look, or Mr. White, it's going to look the same, kind of the same. I mean, it's not going to be something completely different. Okay. Thank you. That was my question.
Because that was sort of the concern with all this too, is that
Yeah.
we couldn't comply with that requirement if with the 14 feet, because we would have to change it, kind of the other direction than we were anticipating, but still, yeah.
Okay.
And I'm sorry.
No, go ahead.
And you stated at the time that taking off any portion of that older house would have just fragmented its construction and would not have been viable. And so I think that was something that we, or some of us, considered as we thought about it and voted a couple of months ago.
Yeah, and then we had testimony from Kelsey, the
Right.
builder, that
Right.
was structurally not viable.
Right, that it was a structural, yes.
Okay. And I do want to put on the record here that the board will be applying the 4 quick check variances just as we did in March, to this rehearing of this application. I'm not going to go repeat all the 4 quick check items, since we did that in the previous meeting, unless you believe we need to do that. We okay with that?
And I'd like to state on the record, we're not asking you to modify any of the
Okay.
findings that resulted in that, or that applied to quick check. Because those are, as I said, findings 1 through 13, which, and then decision number 15A through D are all based on quick check, and we're not asking for any of that to be modified.
Thank you. So at this point, Vince,
I have one more.
you have one more question? Okay.
One of the things I've heard you say, Vince, and I've been going back and forth, sometimes you say no more than 20 feet, and sometimes it's less than or equal to, I believe. So I'm wondering what the phrase is that you are really asking us to consider.
So I'll read the sentences in my letter. It says, however, and this is on the second page of the letter, the last paragraph.
Right.
Now that the error has been discovered, we are respectfully requesting that the board adjust its decision to replace the reference to 14 running feet with the phrase no more than 20 running feet in the second sentence of paragraph 14, so that the sentence now reads, in other words, the grant of relief was to accommodate no more than 20 running feet of the present structure, extending 8.4 inches into the restricted area. Now, that is going to require the same change to be made to paragraphs,
Right, but
the
in,
third and fifth paragraph of the
I
first page.
understand, and I'm really not trying to split hairs here, but I am a detail person.
No, that's-
But on page 9, or on your letter, the very beginning, the second page of your letter, the paragraph beginning recall,
Yes.
you see, and there you say over a length of less than 20 feet. You see how that?
No, and that's a fair
I
question.
want to make sure exactly what the phraseology is that you are requesting.
So that was a quote from the initial letter that we submitted
Okay,
back whenever we first applied for the variance.
Okay.
Just pointing out that we weren't changing anything. We were upfront that it was over a length of less than 20 feet back in that original, actually it's February 20th, 2023.
Right.
In light of all this, and realizing that the survey is 19.5 feet, but there are some overhangs, what we are asking for is the phrase that I read in that.
No more than 20 running feet.
Yes, that's
No
correct.
more than, okay.
Yeah,
So I just want to make sure
No,
I have
that's
it
a fair
exactly what you're asking.
Yeah.
Thank you.
You're welcome.
That's all that I have,
Okay.
Barry, for him.
All right.
I have no
We're
questions.
good? Okay. Vince, is that?
Yes, thank you.
Okay. Matt and Glenn, anything from you?
Nothing further to add.
Okay. At this point, I'm going to ask if there are people who wish to speak for or against this topic. Yeah. Yeah.
Mr. Tudor? Thank you. I guess so. Can you hear me?
So just introduce yourself, give us an address, and then I will ask you to give the oath.
Yes. My name is Karen Medford, and I have owned 38 Park Avenue for the past 40 years.
Excuse me, what address was it?
38.
38, thank you.
Park Avenue for the
Okay.
last 40 years.
Okay.
And
And
Ms. Medford, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
yes, I do.
Thank you.
And I'm over 65 years of age, and I live alone. So I want to say that I appreciate the board giving their time generously to all of these matters, and I know that you make the best decisions that you can. So, and maybe some of the things that I say aren't even, appropriate, like here information I'm seeking. Anyway, I just wanted to say that I used to live in Annapolis, and they had a different way. I don't read the local papers, and so I would urge you to kind of reconsider your process a bit. There are only about 50 houses on Park Avenue, and I think I was the only person who got a letter, maybe the neighbor on the other side, I don't know them. But, and I think, that everyone on the street should get a chance to make comments on these decisions that bear so much on our residential neighborhood.
We can
and I
address that
think
if you
the-
would like. Sorry, excuse my interruption, but the city has a rule for properties within a 200-foot radius. And that's why we ask Ann at the beginning of the meetings, were all these property owners notified? And she confirmed yes. So as far as the city rule is concerned, that we complete
I
that.
understand, I listened also, but I
Okay.
was thinking, I said I urge you to perhaps consider changing them. This may not help my cause.
Yeah, that
but-
would not be for the board, that would be for the city to consider,
Okay,
correct?
Because I think that the people who are most involved, i.e. the Park Avenue residents, should be solicited for opinions or should have every opportunity to give them. And our opinion should have more weight because we're the ones who are affected. Yes, I am very much against this whole process for numerous reasons, but one, because I don't think it will improve the streetscape, and I think it could have a negative impact on my property values. But then more to the effect, I don't have any understanding of the actual steps involved, and I want to know, there are some huge trees in the front yard, lots of them, one of them dead at the moment, that are going to be moved as part of this. This is not just a tear down of an existing structure, this is big equipment coming in, picking the house up and moving it. We live what I call cheek by jowl down here. So if there's some sort of soil that's reconstructed or moved, it could have an effect on my property. And my property is the biggest asset that I have. So I would like some clarification about what is going to happen and who is responsible for if anything goes wrong with my property. My house is in good shape, and I really try to keep it that way. The other thing is that I did listen, of course, earlier to what you said, but it seems to me that if the board doesn't grant this change in the variance, then that actually would nullify the variance and the original variance, and I would urge you to do that. I think that the Park Avenue residents should have more of a chance to say whether they're for it or against it, and again, I would like to know when this is going to take place, and Is there somebody who's going to be responsible for the moving? Do these people have insurance? What happens to me if something goes wrong with this process?
Okay, thank you for those comments.
Is there anything more before we try and answer
Yeah.
any of these questions?
No, I just think, I mean, it's just, because I don't know very much about the process or how it will work, I just want to know, as I said, how it will affect me if you're going to stay with approving the variance. The other part of that would be, I would urge you also to, when you have hearings on items like this that are so important to our little small neighborhood, that these hearings be during the time when most of the residents are actually in residence, so that they can, it's only a small sign in front of the house to get people, if they don't read the local newspapers, to give them notice. So yes, those would be my,
Okay. Thank you. And again, I think we addressed the current requirement of 200 feet.
the current requirement, yes.
To-
So
and
that's
that
why I
was
said I
covered.
urge you
As
to.
as far as probably a lot of these are city building inspector kind of commentary about, does a company have insurance? That is not for the board. The only thing we are, obligated to do is look at the variance from the city code. And we look for those items with the quick check factor of, specific like a hardship. And we weigh on that. We cannot weigh on the color of a building or anything, windows. That is not ours to make. So we have to strictly hold ourselves to the variance in front of us. And whether we approve it or deny it, that's really, and we do look at the impact of that variance request on neighboring properties. That is our requirement. So that's what we look at. But we cannot answer insurance, tree limbs, things of that nature. I don't know if Matt or Glenn want to add anything as far as construction.
Sure. To hopefully set your mind at ease, all contractors are required to be insured in the city before they are even granted any permitting status. The applicant goes through a rigorous review period in that it must meet zoning code and building code alike. And obviously, we do our best to catch all the nuances that we possibly can at the plan level and then at the construction level as well. Basically, that's what your insurance, your homeowner's insurance is for, is to cover the what-ifs, as well as the contractor's insurance and the homeowner that is undergoing the construction. All those insurances are to protect neighboring
Right.
properties as well.
Needless to say, I would rather not, go that route, just have it go smoothly to start with.
It's nothing that the city would get involved with. It would turn into a civil matter if any of your property was damaged during that construction. So you would have to take it up with your own representation.
And when might this construction be taking place?
So what we have, it's a sort of there's several steps. I'm going to go backwards first. We had the hearing on the variance, and I know that Ms. Medford, you sent a letter on that, so there was some participation on that. One of the reasons that we talked about the way the house is placed to actually save some of those trees. So I just wanted to restate that those trees are important. They're very important to Mr. Wagner and his family. So there's, this process. The other thing we have to do is partition the lot into two 50 by 100 lots. That requires a city approval. That's step 2 of all this, which, knockwood, hopefully shouldn't be an issue because they are 100 by 100 all the way around, so there's not any dimensional issues with that. And then Mr. Wagner, with his design team, has to submit plans to Mr. Janis and his internal team to make sure that it's all code compliant and everything with the house being removed. In conjunction with that, we would also, or Mr. Wagner would also have to comply with the city's tree requirements. which either requires preservation of those trees or in the event that trees aren't preserved, which I'm not suggesting is the case, they would have to plant replacement trees. I will say that applies to Mr. Wagner. That also applies to the lot that's next to yours. Once the house is rotated and whether it's his sister or somebody decides to build a home there, that third party would also have to comply with everything we just talked about, building permit plans, tree survey plans, and everything else, including now the silt fences, that you see everywhere else to avoid runoff. So I can't say when it would happen, but there's several steps that need to occur before, you would see construction. I would say, candidly, Matt, if everything goes according to plan, it's not till the fall of this year, just, with plan reviews. And that would be optimal, but that's not necessarily actual.
Right, and recall that you fall under the demolition/house move
Right.
moratorium that ends September 15th.
Yeah.
I'm sorry, the moratorium ends?
There's a moratorium between May 15th and September 15th for demolitions, pile driving, and house moves. Those cannot occur between those months.
That's noise-based, right? That's because of the noise and the nuisance of.
Noise and nuisance.
For people enjoying their summer.
Correct.
Right?
That occurs, Ms. Medford, every year. That's in
Yeah,
the
that's
regular
citywide
city
every
Okay, good to know.
regulations.
That for just a lowly homeowner, we don't know the laws of the land. Okay, thank you very much.
Thank you.
Thank you.
Anyone else wishing to speak? Okay, at this point, we're going to close the public commentary, and then the board will discuss the rehearing amongst ourselves, and then make a motion, and we will then vote on this. Open the discussion. Bill, Edie, any commentary?
We did consider this at great length a couple of months ago. At least for myself, whether it were 14 feet or 20 feet would not have changed my vote in favor of granting the variance. I do think that it meets the quick check factors, particularly the exceptional practical difficulty. In addition, as I said at the time we considered this the first time, I believe that keeping the original older house is consistent with what we are otherwise trying to do with very many of these boards, rather than forcing somebody to have two new modern residences on what would otherwise be the two bifurcated plots. So I think all of that, in my view, remains the same, whether this is 14 running feet or 20 running feet.
Okay, thank you. Edie?
I'm pretty much in agreement with Bill. Nothing's really changed except not more than 5 feet. And it seems that Mr. Robertson and Mr. Wagner and his family are still clarifying and saying that they're going to keep this house as much as they can in its current feeling for the neighborhood. And that, as Bill said, for architecturally, but although I know we can't ask for architecture, but that it's in line with the neighborhoods. And we had such an extensive discussion and presentation about this a couple months ago, and I don't see anything that's fundamentally different except for a measurement. So
Okay, thank you.
I'm in favor.
And as I stated before, I went back and I watched the lengthy discussion and the
Yeah.
video from the meeting. And looking at this, I was leaning towards this is more of an exceptional practical difficulty for the distance. I mean, I know Mark was talking about, can't you take the wall off? And then I'm thinking, geez, you take the wall off, there goes the bathroom, there goes, and I'm like, so the way I'm thinking that this is even more justified as an exceptional practical difficulty for, for approving this. So that's just where my head's at. So at this point, if no other discussion matters, like someone to make a motion?
Well, I can try. I move that are we saying we're amending, or what are we doing? Fred, maybe you can help me. This
I
goes back to
think
my original
we're-
question.
We're extending if the motion is to approve the application, it's to extend the running foot measurement that was referenced as 14 feet to no more than 20 running feet.
But I think where Edie was going was right, but we don't want to, otherwise we would have to repeat every
But
finding.
we're
we previously
piggybacking
made.
then, yeah.
I think what we're saying is we are voting to, the motion is to modify or amend the prior decision to reflect, properly reflect that the running feet are 20 feet instead of, no more than 20
No
feet.
more than.
Rather than 14 feet, and otherwise to reaffirm the findings and decisions we previously made.
By saying extending, I probably gave the impression that you were considering a newer request or something, but actually it's just to strike the term 14 feet and replace it with something that could be read to mean not greater than 20 feet.
Well, then, in the notice of decision, though, you know, as we've seen and Vince pointed out, the 14 running feet is listed more than once.
Right.
So it would have to be amended. The other thing is, the other small change we would have to make is there was a mathematical error previously in the square footage, because somebody multiplied inches by feet and to get square feet, which of course isn't quite right, because 8.4 inches is 0.7 of a foot. So 0.7, so we have to, what we're doing is we're going to multiply 0.7 by 20, correct? To fill in square footage, because we've got to correct that as well.
Right.
So 0.7 times, oh, I did 19, but 0.7 times would be 14, right?
Yeah.
Yeah. So it would be 14 square feet. So that too, I mean, it's not changing anything anybody said today. We're correcting to make it all appropriate. So now how do we move that?
I do, like you said, amend and affirm. I think that's key in this decision.
Do you want to try the motion, Bill?
I would move that we amend and affirm
That's good.
the notice of decision dated, what was the date, Fred, of the original one, or Vince?
May not said.
Well, that's when we received it. It was dated
Oh.
April 24th, 2023.
Dated April 24th, 2023, to reflect that the running, what is the term? Is it,
The encroachment,
but the
Or
term
running.
is, the 20 feet is referring to what, running length of the encroachment to not exceed 20 feet rather than 14.
no more than 20 running
No more
feet.
than 20 running feet.
We've still not got it quite clean, do we?
No,
That's
that's
pretty
good.
good.
That's
Okay,
sufficient
good.
for my purposes. I
Is
think.
it?
Yeah.
Because he'll write it up,
And there is no change in the depth. We all agree on
Right,
that.
yes.
right.
Which properly reflects, it'd be no more than 14 square feet.
Right, right. So we need both of those calculations, since they were both on the decision.
And that we otherwise reaffirm the prior findings and decision of our prior hearing.
I'll second that.
Second that. All in favor?
Aye.
Oh,
Aye.
well, now we have to, excuse me, I recant that. Now we have to take a vote.
Oh, I
So
have to
you-
say why.
Yeah, yeah.
Were you going to reiterate the quick check or no?
No,
Okay.
I don't think
No,
we
we
need,
don't
I
have
thi- I
to.
think we
So
need
we don't
that.
have to do that today to talk about quick check?
You could state it in your reasoning.
Yes,
Yes.
I would like to. I agree. Quick checks number 1, 2, 3 we found before, and I affirm that they are not relevant to our denying anything here. And quick check number 4, I actually agree with you, Barry. I felt that this situation created more of an exceptional practical difficulty if it was not granted. So I'm in agreement, and I vote positively towards the motion.
Okay. Bill?
Yeah, I agree with Edie's comments and believe that quick check factor 4 is the key factor here, and the failure to grant the variance would present a exceptional practical difficulty for the owners.
Thank you. And I vote to approve this, the motion, the amended, the amended variance. I do see it as an exceptional practical difficulty, and I do see, saving a house in Rehoboth is, the right thing that the city wishes. So in today's board, we needed all three to vote in favor to make this motion pass. So this motion has passed. Thank you, everyone. And do we have any other business to take care of? Okay. And any cases on the table for next month? Okay. All right, everyone.
They won't happen.
I know. Thank you, everyone. Thank you. Meeting is over. Thank you.
Thank you.